Welcome back to Pace Immigration, paceimmigration.com, talking with immigration lawyer Michael O'Rourke. Michael, good to see you. How's it going?
Great, John. How's it going with you?
I'm doing very well. I've got some questions for you today. We've got our mailbag. Is in the room. Yes, and I'm going to post some questions out of it. These are questions that we take, either the emails that come in or comments off YouTube that we think might be of value to others to take a look. Almost a free consultation with Michael O'Rourke here. So we'll dive in and take a look at the first one. There's a lot of words here. I'll truncate it a little bit. We have edited some of these for clarity, but we've got here, I crossed the border for 3 years freely with my status card, long haul driving. And this was on your J Treaty video, this comment. So it's dealing with crossing the border under indigenous status. One day refused to give a class 2 inspection. Now I'm refused entry until I can provide a genealogical report of my family history. And it goes into all kinds of detail here. It also mentions a criminal record. Michael, what's going on here?
So it looks like CBP had questions about the bona fide Indian status of this truck driver. Of course, everything depends on the facts, and you're going to hear me say that a lot today. But if the status card wasn't one of the secure status cards, that might be a reason why CBP is asking for the genealogical history to show that this person actually is a member of a recognized band. Once CBP does flag somebody, though, even though the person has a right to cross the border, to work, to migrate, to settle in the United States, they can still raise security concerns. So my suggestion would be to go to Northern and Indian Affairs, get your genealogical history, and bring that with you the next time that you do cross the border. If there is something, if you were denied entry, or if there were any, if you were given any sort of paperwork about withdrawing entry to the United States, then I would definitely talk with a lawyer once you've gotten your genealogical history, because you might have to file a waiver. But in general, once there's a red flag, you have to do what CBP is asking. Otherwise, you will continue to have problems, whether you have a right of entry under the J Treaty, whether you are just a Canadian citizen who can come into the U.S. visa-free. If there's a security concern, we need to address it.
Right. Okay. Moving on to this one. This one is dealing with the Uniting for Ukraine program that was brought in earlier in 2022 as a result of the war going on over there. This one says, hello, I'm a Ukrainian citizen. My brother is an American citizen, and he started the process almost 2 months ago. It was approved, and I received an email from the authorities. I opened the account and filled in all the info they requested. I have not received any information since then. How long can this process take? I'm assuming here, Michael, that my brother is an American citizen. They're saying, so they are Ukrainian trying to get to the United States?
Yes. So it sounds like it is a question under the Uniting for Ukraine program. And unfortunately, they have not yet published timelines of what we can expect. So sometimes we see an intending immigrant. I don't want to use that word, but we see a Ukrainian citizen intending to come to the United States as they get approved right away. Sometimes if there's some difficulty in verifying certain aspects of their identity, or their financial holdings, their bank accounts, their work history, things like that. Since every case can be individual and everybody has their own unique set of facts, it might depend on what was filled in on the application form for this person. It might be that it's just taking longer than usual, although we don't really know what usual is right now. So I would suggest, if you have gotten this email, filled out all of the information, and it's now a couple months later, I would try reaching out to USCIS to see if there's any way to move this forward. And I would probably do that first by calling their 800 number and asking to speak with one of the representatives who can help you with Uniting for Ukraine. That might then be kicked up to a supervisor, and maybe you can get some information that way.
Okay, so we have this next one here, dealing with criminality. I overstayed for 2 years, 2001 to 2003. I stole a phone card in New York in 2003, and that was 20 years ago. I got caught. The police brought me to the NYPD. I did some fingerprints and gave papers. They gave me papers to go to court. But before the court date came, I ran away to my home country. Can I apply for a U.S. visa and re-enter the U.S.? I did it when I was 17 years old. Michael.
Okay. So there's a lot going on here, and something that our writer hasn't mentioned, but has probably happened as well, is that the court where this arrest was referred probably issued a bench warrant when he or she failed to appear. So I think the way that I would approach this first is to hire a New York lawyer to figure out what the status of the criminal complaint is against this person. From there, see if the court that likely issued the bench warrant would consider quashing that warrant, maybe even negotiate with the prosecutor if there's a way to resolve this prior to applying for a U.S. visa. So if there is an open criminal prosecution against you, you're not going to get a U.S. visa. That's all there is to it. But if the person can show that this has been dealt with, that they are now an upstanding citizen in whichever country that they live in, that they don't have a further criminal record, then after everything in New York is taken care of, I would certainly try to apply for a visa. The consulate dealing with this visa application would likely have to refer the case to the admissibility review office for their opinion. They might also refer it for the issuance of a waiver, but it is possible, but you have to get rid of, or you have to put to bed the outstanding criminal case, which is still probably out there.
How about a U.S. citizen that has a conviction and wants to sponsor their wife? This one I found kind of interesting. Does it affect the application? What if the sponsor is still detained?
Yeah, so it is interesting. Technically, there is no bar. Well, depending on the conviction, there's likely no bar to sponsor a wife. But the person who is sponsoring has to show that they have an income that would support the family size on an affidavit of support when they're making this application to sponsor their spouse. So if the person is still detained, for instance, and doesn't have an active income and doesn't have sufficient assets to support their spouse when he or she arrives in the U.S., then it might be denied because of that. So
interesting.
Okay. Yeah, it is interesting. There again, this is one that we should look at the totality of the circumstances to see what type of conviction is there going to be a chance that the couple can actually live together, and does the U.S. citizen actually have sufficient resources or income to support an application like that?
Okay. Here we go with the more theatrical stuff. I put up the comedy and the drama mask there, which is also kind of a lot in immigration.
Yeah,
because
seriously.
You're applying for things and getting all happy about it, and then there's those long waits and things. So anyway, we've got here an actor from Canada. I was told the O1 could take 3 years, even as a Canadian. I'm a Canadian actor looking to get that O1. Any thoughts?
So the 3 years is actually how long you can usually get an O1 visa for it. It can take a while, but it doesn't take that long. What you have to do as an O1, of course, you have to meet all of the application requirements. If you or your employer in the United States or your agent files with premium processing, this is an extra $2,500 fee to the U.S. government to expedite an application. They can theoretically return a response in 14 working days. So that response might be, we need more information, but that's on the fast track. If you file the O1 petition without premium processing, I would say it generally could take anywhere between 3 and 6 months for them to get around to processing it. So it won't take 3 years. And if you're a Canadian, once you have that petition approved, then you can come to the border and come in O1 status.
Right, and 6 months doesn't sound that long right now, does it? There's so many delays in immigration processing right now all over the world, but especially in Canada, that 6 months sounds okay.
6 months is pretty fast.
Yeah, right. Okay, moving along, we have here, may I ask, if a U.S. citizen is applying for Canadian citizenship through spousal sponsorship and they don't have a criminal record, do they need to show police checks from each state that they've lived in, or is it enough to show the FBI federal check?
FBI is enough. So just to correct, I think what the questioner is asking is he or she is applying for permanent residence using the spousal sponsorship process. Unfortunately, you can't go right to citizenship in Canada or the US. You have to be sponsored. You have to be a permanent resident for a number of years, and then you can apply for citizenship. But FBI is usually enough. The only time that we really see state police checks are when somebody's applying for a temporary resident permit or criminal rehabilitation.
Okay. What about investors starting a business, but that is part of an existing U.S. franchise? Is this a easier option, easier option, or is it better to start your own independent business in the U.S. in order to get the E2 investor visa? Michael, maybe just a quick recap. We've talked about it before on what the E2 is and whether or not you really have any opinion on starting your own business or a franchise.
I always have an opinion, Sean. Yes, but my opinion is that there's really no difference. So whether you start up your own business from scratch, or you acquire an existing U.S. business, or you buy into a U.S. franchise, it's all going to be the same process that the U.S. consulate in Toronto goes through to understand your business, to go through the financials, to make sure that your business is operating, that your money is at risk, that the investment is substantial enough to operate a business of that type. And then it's more than marginal, which means that you are going to make money in the long term that will be more than just paying your salary and eking out a meager existence to live in the United States. So as long as you can do that with your own business, yeah, that's fine. I don't see any difference really between a franchise or your own business or acquiring an existing business, except for the franchise might have a better package of documents, and you won't have to go hunting for as many things from different professionals. Usually franchisees have everything all at their fingertips, but in general, right, I think it's going to be about the same.
Okay, Michael, thanks again for this round answering immigration questions. If you have any questions, please feel free to contact us. You can get us at info@paceimmigration.com. You can also email Michael at the address you see on the screen, morrourke@pacelawfirm.com, or catch us online on all the social media channels, including YouTube. Michael, thanks a lot. We'll talk to you next time.
Sounds great, Sean. Take care.
Bye-bye.
Bye-bye.